Welcome everyone to the Federal Bar Association Key Tam Sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of FCA decisions. I'm Scott Oswald, chair of the Key Tam Section with Tejinder Singh, who is a partner at Goldstein Russell. Tejinder, hello.
Hey, Scott.
So let's talk about some cases.
Let's do it.
So the first one that you have for us is Fallon versus Bell Transit. Want to tell us a little bit about this case?
Sure. So the important thing to know about this case is it's a case that was brought against a school district and the school district's employees. And this matters because when you bring an action against a state or an arm of the state, the general rule is that you can't do that. You cannot, because the state is not a person under the False Claims Act, you cannot sue a state. And so this action was brought against the school district and also individual school district employees. And a debate arose about whether you can do that. And so what the district court in this case finds is it finds you cannot bring an action against the school district directly. However, you can bring the action against the school district's employees. And naturally, the defendants say, wait, if you do that, you're effectively bringing an action against the district because the school district is going to indemnify its employees. And so you're getting money basically from the state if this action is allowed to go forward. And the district court's response is basically, yeah, whatever, it doesn't matter. And that's under existing Ninth Circuit precedent, this case called Stoner. And the reason why this is interesting is that there is an ongoing, shallow but real circuit split about the circumstances under which you can sue an individual employee. And the Ninth Circuit has basically said, you can do it. It's not a problem. That person is a person, whatever the indemnification rules are in the background, it's okay. The Eighth Circuit, on the other hand, has said you can only do this if the person was acting outside the scope of their authority when they were acting. And so it raises this interesting question about what's going on in these cases with immunity and with the states.
And for relators counsel, it seems kind of interesting to me because if the person is working, acting within their authority and they're getting indemnified, that might mean that a judgment against that individual might be paid by the state, right?
I think that's absolutely correct. I mean, I think the state's only remedy in that situation is to just not indemnify people, which, it may not want to do that. So it's quite a challenging thing for states, I believe. But yeah, from the relator side, I think what this creates is, some mechanism, if you can identify the individuals responsible for institutional fraud, to nevertheless kind of get full value on those claims to make sure that somebody can be held fully accountable, even if the school district could not be. And I guess, the question probably comes back to, do you think states ought to be immune when they, for example, defraud the federal government? And I think that there's a pretty good argument that maybe they shouldn't be. And so, while one could look at this as, oh, it's expensive, it's scary liability, the other way to look at it is that, certain defendants were getting a pass before and now they're not.
Let's talk about Martino-Fleming versus South Bay Health Centers. What's this case about? Kind of interesting procedural posture, right?
Yeah, so this is another case in the district courts, and it's in the District of Massachusetts, and it's a healthcare fraud case. And what's interesting about the case is, as you note, the procedural posture. So this is a case where the relators have done something that I think from the plaintiff's perspective is often a little bit unusual. They've moved for summary judgment on certain elements of their claim, falsity and materiality, and they've gotten it. And so I think what's fun about this case, or what's a useful teaching moment about this case, is that you can have situations where that certain things were false, requirements were clearly violated, for example, that this is related to how the government pays claims, or it's actually affected the amount the government has paid. And in that situation, as a relator, it may well be worth your while to move for summary judgment affirmatively, as opposed to just opposing the defendant's motion for summary judgment and being in a defensive posture. And so in this case, you're seeing the relators do that with great success. And what's nice about it is, it will, depending on the timing, it can narrow the scope of discovery, it can accelerate your path to a resolution. But I'd hold it up as a decent model for what to do when you're trying to figure out, when things seem legally to line up for you, to push or not to push. I think this is a good case for pushing.
And for those of you who have participated in our FCA Today series, Judge Saris was our judge for the FCA Today Massachusetts in the spring. Pretty neat to see her name on that opinion, Tejinder.
Oh, for sure. And, I think it's actually, it's telling in a sense, the more judges are educated about the False Claims Act, the more I find they tend to rule our way. It's a thing where I think there's a lot of traps, there's a lot of nuances, but I think the more educated the bench gets, the better the decisions we're seeing, for sure.
Let's talk about the Bibby case from the 11th Circuit, Bibby versus Mortgage Investors Corporation. Tell us a little bit about this case.
Yeah. So this is a case about loan guarantees offered through the VA. And it's one of a number of cases brought against a number of banks, many of which have already been resolved successfully. But this is a case that got thrown for a little bit of a loop after the Escobar decision by the Supreme Court on this question of materiality. And so there's this discussion back and forth in the case about how these loan guarantees work, and are they, are violations of certifications connected to them material to whether the government's going to guarantee the loans or not. And what's notable in Bibby is that the 11th Circuit undertakes the sort of what I think is the new normal after Escobar, a holistic, multi-pronged materiality analysis where it asks, is this a condition of payment? Does this go to the essence of the bargain? How has the government behaved before? And it, balances all these factors against each other and says, well, this pretty much looks like a jury question because different things kind of go in different directions. And what's particularly useful about Bibby is that this is a case in which the court does conclude that the government had actual knowledge of certain non-compliance, but nevertheless decides that the case can go forward. For a minute after Escobar, everyone thought that if the government kept paying claims with actual knowledge of some violation, the case was over, right? There was nothing else to do. And that's because in Escobar, the court said this would be strong evidence against materiality. But then over time, courts have kind of come around to say, well, no, not so fast. You can do this in a more nuanced way. And even if the government has continued to guarantee loans or pay claims, there may be situations in which there's still an argument to be had for materiality, or at a minimum, it would be a jury question. And Bibby is a great decision for that proposition.
So you mentioned Escobar. We're right about at the 5-year mark since that decision came out. It's been up and down on how folks have interpreted Escobar. Tell us kind of where you come out. Where is the current state of the law, and what can we expect in the future?
I think Bibby is a good illustration of the current state of the law. Courts are undertaking these kind of holistic inquiries. They're, balancing the factors. I think there are some circumstances, though, and Martino-Fleming that we just talked about is a good example the other way, where you can actually show materiality as a matter of law on the plaintiff side, and where it's still worth it to try. And so I think getting too wrapped up in it's all holistic, it's a cloud, the jury will figure it out kind of model is not necessarily the right way to litigate these cases. But where I'd say we were is right after Escobar, the lower courts looked at the language of that opinion and they said, oh, the Supreme Court is saying the materiality standard is rigorous and demanding. It's saying that this would be very strong evidence. So as I said, if you had a situation where the government has paid claims, after the complaint was filed or similar, district courts were quickly throwing those cases out, just saying, okay, and they're doing it at the pleading stage, motion to dismiss. If they're still paying the claims, this thing is gone. And then I think a few appellate decisions came back the other way and said, no, you've jumped the shark here. You got to undertake this holistic inquiry. And now that's kind of where the law has settled in most cases. And I would expect it prospectively to be, that unless Congress acts again or the Supreme Court acts again. I think on that materiality question, Escobar has kind of settled down. There are some questions about whether the materiality standard only applies to implied false certification claims or whether it applies more broadly. There's sort of a debate still going on there. But for the most part, I think the new equilibrium is pretty much what's reflected in Bibby. Most cases are going to have a holistic inquiry. If factors go in multiple directions, then it's going to be a jury question.
So our final case, let's talk about the public disclosure bar, Rosenberg versus JPMorgan Chase. You know something about this case, Tejinder?
I do know something about this case. I lost this case, and so it's a sore spot, but we can talk about it. The case is about a fraud, an alleged fraud having to do with the marketing of certain municipal bonds. And so what these bonds are is they're called variable rate demand obligations, and they are variable rate bonds. So their interest rates go up and down depending on what's happening in the market. And the way you're supposed to set the interest rates on these is that a bank is supposed to go out into the market periodically and see what is the best rate I can get. And when you're the government, a low interest rate is good, right? You're borrowing money when you sell bonds, and so you're trying to get the lowest rate you can get. So the bank is supposed to go out into the market and get the government's the lowest rate. And the allegation in this case, which is brought by an industry expert who knows a lot about the municipal bond market, is that the banks weren't doing that. Instead, they were using a set of fancy algorithms to reprice bonds periodically without going into the market and checking what the market would really give, but instead algorithmically based on other variables. And the effect was twofold. For certain bonds, bonds that had no correlation to each other in terms of credit risk, their rates were still moving in lockstep, which they shouldn't do, right? The interest rate you get on a bond should always reflect how risky it is. And that wasn't happening. But second, the government was paying more in interest than it should have. And so governments across the country, municipal governments, were getting harmed. And so he brought FCA complaints in a number of jurisdictions about this, one of which was the Commonwealth of Massachusetts, which is where this case arises. And so that's kind of the basic background about this. And if you're still awake, then what happens in the case is that the defendants say, look, all this data about bond repricing, you can get this from this website run by the MSRB, the federal government's body that regulates municipal securities. And they have this website, and you can get this bond data. You can look it up for any bond on a daily basis, see what the rate was. And because the data is out there, and because so much of the analysis you've done to figure this out is based on this data, this whole thing is publicly disclosed. The underlying transactions are publicly disclosed, the public disclosure bar applies, and you lose. And the trial court said, yes, that's right, ruled for the defendants. The case was appealed, and while it was sitting before the Massachusetts Intermediate Appellate Court, the Massachusetts Supreme Court swooped down and said, we'll just take this directly. And apparently this is something that happens in Massachusetts, where the Supreme Court has decided, well, this is an important enough issue, and we're probably going to have to talk about it anyway. We'll just grab it now. And so the case just got scooped up and immediately sent to the Supreme Judicial Court of Massachusetts, which also ruled in the defendant's favor. And as relevant here, what they said was this website run by the federal government's organization is the news media. It discloses all the relevant transactions, and the relator can't be an original source just based on an analysis of that data.
This website, it's kind of like Pacer, right?
It is. And so, what the website does is different entities have to report, and they get reports daily, hundreds of them, maybe thousands, of what the rates are on various bonds. And the website in real time puts that information, on the web. So these are regulatory filings that just come in daily. So it's also similar to the SEC's website, EDGAR, where people are making securities filings. And so, I think the points that are relevant about it are that it's a government website, and that it is all it's doing is spitting out in real time data that's coming in through regulatory filings. It's not, we wouldn't ordinarily call it the news media in the sense that there's no commentary or editorial content of any kind. There's no judgment that goes into what gets printed and doesn't. It's just whatever the regulatory filings say, it goes on the web, right? The website's called Emma, by the way. So yeah, it is in a way, it's like Pacer or the SEC's website or any number of other government websites that sort of regurgitate filings that come into the government.
And so the implications of this, what are they?
Well, there are two. So if I had to say why the decision is wrong, I think there are kind of two big reasons why I disagree with this decision. The first one is they're interpreting the phrase news media. And as I've already said, we wouldn't ordinarily think of this as the news media, this kind of website. Now, there is a debate out there in the case law about whether every website is the news media. And the Massachusetts Supreme Judicial Court, to their credit, doesn't accept that crazy broad argument that everything on the web is news media. But they do say that pretty much every website designed to disseminate information is going to be the news media. And so, you know, there's this issue where I think what often happens is, and this is what kind of a product of textualist statutory interpretation, is people say, okay, we're going to interpret news media according to its ordinary meaning. And what they do is they say, what's a definition of news? Well, news is anything that happens, right? What's the definition of media? Well, it's the channel of communication. Therefore, news media must mean any channel of communication describing anything that happens, right? And that leads you to like an apocalyptically broad definition of the news media, which is not how we use that phrase in ordinary language, right? In ordinary language, news media is the professionals who report on the news for a living. It is like a very small subset of the information that's out there. And so, you know, I think that there's a principle of statutory interpretation that wasn't applied here, which is when you interpret a phrase, you use the ordinary meaning of the phrase and not just the ordinary meaning of the individual words in the phrase, right? What are the implications? Well, you kind of alluded to one earlier, which is Pacer. So the public disclosure bar has this really odd structure. And here I'll talk about the federal public disclosure bar, but the state one works basically the same way. There are three channels of disclosure that can qualify. The first one is, in the federal context, it is a federal criminal, civil, or administrative hearing in which the government or its agent is a party, right? And in Massachusetts, it's a Massachusetts criminal, civil, or administrative hearing in which the Commonwealth is a party. The second one is a federal report, audit, investigation, or hearing. And it specifically in the federal context says a congressional report, a GAO report, or other federal report. And in the state context, it's the state counterparts. And then the third one is the news media. Now, this structure is not an accident, right? These limitations in the first two channels, which limit them pretty sharply, were added in the Affordable Care Act. So in the federal one, they said, it used to say it could be triggered by any criminal, civil, or administrative hearing. But in 2010, they narrowed it. They said, no, it's only a federal criminal, civil, or administrative hearing in which the government or its agent is a party. So under the old statute, if you had a lawsuit between two private parties, you and me, that could trigger the public disclosure bar if the relevant frauds came out during that. Under the new statute, if the government's not a party, it doesn't count, right? No matter how explicit the disclosure. The problem with treating the news media as anything that gives out information is Pacer, which you alluded to earlier. If the news media covers every website that gives out information, then it must cover Pacer, right? If it covers Pacer, then a private lawsuit between me and you, all the records of that are in the news media. And so even though Congress deliberately sought to carve them out of the public disclosure bar when it narrowed the first channel, they're still there under the third. And that to me just suggests the news media can't be that broad. It can't be every website that wants to give out information, because that is exactly what Pacer is, right? At a minimum, there has to be an exception for things that were deliberately carved out of the other channels of disclosure at a minimum. Otherwise, the news media thing is way too broad. So those are the reasons why I think the decision is probably wrong.
So talk to us about what the implications are of this for data miners, right? Whether it's PPP loans, doctors' bills, what's in the future for data miners?
I think it poses a real challenge. I think that if you have a situation where what you're basing your claim on is a review of a publicly available data set, and you've figured out that there's some anomaly in the data set, under this decision, if that data is available on the internet, then it seems like the Massachusetts Supreme Judicial Court, at least, would be likely to find that it is publicly disclosed and that discloses the transactions underlying your claim and therefore triggers the public disclosure bar. I'll note that the Massachusetts decision is, of course, not binding outside of Massachusetts, and there are some courts that went the other way. I mentioned the same relator at issue in the Rosenberg case has other cases around the country, and courts in California and Illinois have rejected the public disclosure bar defense on virtually indistinguishable facts. And so it's not open and shut that the Massachusetts decision is right. In fact, I think it's wrong. But if it's right, if it were followed, I think the implications for data mining are quite negative. They create, a real risk of those cases being barred in almost all situations, because as long as the data set is publicly available in some form. Now, if it's not, then you may be dealing with, kind of a different story. But if it's available in some form, then I think it's real trouble.
Tejinder, thank you. And that's it for this edition of The Rounds FCA News with Tejinder Singh. Look forward to seeing you next time.